Hi, everybody. We are now on week 4. We're in the home stretch for finishing this class. Week 4 discussion is a little bit more difficult than the questions we've had in the past. It discusses the exclusionary rule and investigations. First, we need to know what the exclusionary rule and investigations mean. We need to know what the Fourth Amendment means. In this one, they want you to know the Fourth, Fifth, and Sixth Amendments. But in deciding all of this, we first need to look at the Fourth Amendment. So I put this up here. What does the Fourth Amendment mean? The Constitution through the Fourth Amendment protects people from unreasonable searches and seizure by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but those that are only deemed unreasonable under the law. See that word unreasonable? What is unreasonable? So is it unreasonable that I knock at your door at 2 in the morning and I ask to search your house without a warrant, that I can just go in there? If I ask and you let me in, can I go in? So we're going to talk about the exemptions to the Fourth Amendment, and there are many, but the ones that are the important one is if I ask you if I can search your, what you have on you, your backpack. If I ask you if I can do that, and you say, "Sure, go ahead, have a go at it," and you don't think that I'm going to do it, and I do it, and I find something that's illegal in there, and you've given me verbal permission. It doesn't have to be written. You've given me verbal permission, then I can do that search. If I find something during that search, it leads me to like a cell phone, and I say, "Can I check your phone?" And you say no, then, or a computer, I need to get a warrant with probable cause to look in a phone or a computer. Now, there is exigency, and exigency is important to know. So if I have somebody that's suicidal and I know, or I have enough probable cause to show that that there's information on there that will help me save that person's life, I can show exigency and I can go into that phone. But don't think for a second that that doesn't have to be written, documented over and over again, and I better be able to show why there was exigency. Just can't arbitrarily say, I'm going to make exigent circumstances here and just make it be done. So if there's a search and it's incident to a lawful arrest, I can search you. But can I pull you over and have you come out of the car and do a pat frisk? Absolutely. I can do that under the cover of a number 1 for safety. So I'm able to do that. Am I able to put handcuffs on you while I search your vehicle? Yes, I can do that under, the area that it's for my safety. Probable cause to search and seizure and exigent circumstances fall under Payton versus New York, and that's an old case. It's a 1980 case, and you can look at that case. A lot of our cases having to do with search and seizure go way back. It is probably one of the most daunting areas I found on my work. It was like, okay, is this exigent? Do I have enough time? Will somebody be hurt if I don't do this search right now? Will I lose the evidence if I don't do this search right now? How can I keep this evidence and still get a search warrant? So keep in mind that things have changed in the last 30 years. Computers, phones, those are all require their own individual search warrants to go into. I just can't arbitrarily go into things that require, access into them. What happens, let's throw a little glitch in there. Let's say that my 13-year-old son is there and I say, "Hey, can I look at your son's phone?" Is there a reasonable expectation of privacy? You have to ask yourself this question over and over again. And I will be honest with you, I think sometimes I look at what court I'm dealing with when I decide that. Say I want to go into a 14-year-old's bedroom because I feel that there's exigent circumstances, that there's a crime that's about to happen and there's evidence of he or she in there. If I can get a parental consent, and that room has other access. It's not only one person has access to that room, that parent had access to that room. I can show that by saying, "Mom went in every week and brought laundry." There's certain things I'm going to have to put in my report. I have to be able to show why I could go in there with the parental reasoning. And we found that in Massachusetts that's what you have to do all the time. You have to show reasonable expect that you've gone past the reasonable expectation of privacy and that the parent has been able to give permission. And on that note, does that mean that I need to have a warrant to go into a student's locker? I do not, because there is no reasonable expectation of privacy in a locker in a school. And a lot of that came after that's come in the last couple of years because you'll have police search lockers. They'll do those all the time. Do I need a police dog to walk up and down the hallway? No, I don't. Do I need a police officer? I mean, do I need a search warrant to have a police officer walk right up and down the hallways with a drug dog? No, or a bomb dog. Do I need it to have a drug dog or a bomb dog go around a car? Do I have, do I need a warrant for that? No, I do not. So those are things that, believe it or not, it is the hardest part of the job. It's probably the Fourth, the Fifth, and the Sixth Amendment to know, am I in the right or am I in the wrong? So your question this week is going to be, decide whether evidence obtained in the warrantless search should be excluded. Provide reasons for your decision. So as a police officer, in my career, I've had evidence thrown out. I thought that I had, just cause for it. I tried to never break anybody's rules, but one of them was really kind of funny because it was, it wasn't much, it was a few 8 balls of crack cocaine, and I said, the kid had them throw out the evidence, and okay. Well, then he came over to the police department. And he wanted his property back, and I'm like, we do not give illegally possessed stuff. It's illegal to have possession of. You do not get it back. What do you mean I don't get it back? So it's actually kind of comical that sometimes you think you're going to get that stuff back, but you're not. You just really, can a case go forward without that piece of evidence? Maybe, maybe not. So we look at those now and we say, do you have the right to go into an area? Does that person have a reasonable right to expectation of privacy? And considering there's some of those, I mean, I think there are some cases that have to do with it, even if you have a case where they said you didn't, that evidence can sometimes be put into court. So don't think because it was found illegally that it can't get in, because it can get in. And we'll go a little bit through that. Fruits of the poisonous tree. I heard this my entire career, and you'll hear this entirely in your career. And it falls under the exclusionary and evidence admissible. And it says if the tree is tainted, then so is the fruit. If the tree is poisonous, then you better not eat the fruit. And that falls under the 1920 decision. And it's fruit of the poisonous tree. To this day, it stands. All right, to this day. So, like the exclusionary rule itself, this doctrine is subject to 3 important exceptions. The evidence will not be excluded if it was discovered from a source independent of the illegal activity, its discovery was inevitable, or if there's an attenuation between the illegal activity and the discovery of the evidence. So know that some evidence will get in. There's good faith exceptions, and that's, did you have good faith when you got it? We also have plain view doctrine. And the plain view doctrine has changed over time because now we have drones. Can drones get information out of your backyard that they wouldn't have gotten before? Did you expect to have plain view then? Did I expect to, if I drive by your house and I see that you have a grow going on, did I expect you to think you had privacy? So those are some of the things that you have to look at. The next thing I wanted, and I'm going to give you these links. Consent to home searches. Who can give consent? Can a boyfriend give consent to his girlfriend's house? Did they both live there? You cannot search I can't search my sister's house or somebody's sister's house by, me giving permission for you to go into my sister's house. It's not my house. I don't live there. So consent to home searches is really important to know. Who has the right to give consent? If there's a party going on and a kid opens the door and says, come on in, and it's not his house, and there's all kinds of illegal activity going on there, did he have the right to invite you into the home? Those are big questions. How about college houses? I have one near me. There's, like 12 kids living in there. Who has permission to let a person in? So I will give you this page as well. The exclusionary rule, how it can lead to tossed evidence. I thought this was a really interesting read. Remember, a search incident to a lawful arrest. Let's talk about if I arrest you for some drug activity, can I do a strip search? And Massachusetts has answered that very clearly on strip searches. So we're going to talk a little bit about that. You have to have exigent reason why you will do a strip search. Many have been thrown out. You just can't do that. And they're saying now that you should avoid those. So doing a search is an art. I hate to use it as an art, but it has to do with art, because I can tell you, when I first came on the job, we had a guy that was arrested for stealing, and to show you how long ago it was, from an Ames. And he had 27 different knives and axes that he had hidden in the crotch of his pants. Can you imagine what that search was like? So when you're doing a search, you have to be able to articulate what you're looking for, but you have to articulate why you had someone take a piece of item of clothing down or away. You need to be able to say, you felt this hard object, it felt to you it could have been a weapon. You have to be able to put that in your report. If you don't put it in your report, the rule is if it's not in the report, it didn't happen, and therefore it will be thrown out. So you can search a person, but you can't strip search them without reason. Plain view. You can seize any evidence that's in plain view during a traffic stop. So if they have anything on the front seat, their back seat, you can search a vehicle as well. Whatever they had room, wherever they were able to reach, you have the ability to search that. That is a really tricky in our courts right now, so you have to be very careful and make sure you have to write exactly why you did it. Due process. I wanted to talk about crime and due process. And this here will be, due process is so important to know. It falls under the Fifth Amendment. Everybody has a right to a fair and speedy trial. What do you think a speedy trial in Massachusetts is right now? With after COVID, you're talking 4 or 5 years behind. When I had cases that were really big cases, they were often at least 2 to 3 to 4 years behind. There is no speedy trial anywhere. Trust me when I tell you that. Speedy trial is not what you think it is. It's very, very extended amount of time. So I'm going to be cut off here shortly, so I'm going to give you that as well. And then on this here, I'm going to give you the lost effects of the Fourth, giving personal property due protection. This is under the Yale Law Review, and it's a good article to read if you have it. It talks about persons, houses, and papers, who has the right to go into them. And then the legal, independent source, inevitable discovery. Would we have found it even, what would, inevitably would we have found it? And so therefore, can it be held, can we use it as evidence? Told you this was not going to be an easy week, and I hope this helps you understand all of these. I'm going to give you a few things and send them to you, but I now want to go to the next part of this, which is going to be assignment, which is a traffic function. I think this is probably one of the more interesting things that you'll find this week to do as well. What are the advantages are there to having a traffic collisions investigated by the police? Well, one thing for sure is that they'll be able to document there are certain areas that need to be changed due to the traffic flow that are maybe causing accidents. Very often people think it has to do with insurance. I think many people don't realize that insurance investigators are responsible for finding who's at fault, not police. Police do not find out who's at fault for insurance companies. That does not happen. What are the disadvantages? Well, the disadvantages are very often the public hates you for giving out any motor vehicle citations. So your community relations sometimes goes down the tubes. And that's really important when it comes to the relationship with the community. So I have a couple things that are on here. Using police officers' expertise to improve the reporting of contributory factors. This is extremely important for to find out, do we need to change the flow of the traffic in the city? Then I'm going to give you Police One that has Boost Police Community Relations. And they're telling you, maybe we shouldn't be giving out so many tickets. And how about if you lower the price of the tickets? Stop making it off the back of people. When you look at Ferguson, that was one of the issues with Ferguson. They were using traffic citations to fund the police department. That never makes a happy community. The next thing we're going to look at is vehicle effective high visibility enforcement. HVE is going to be something that you all should know. HVE plans, they aim to reduce harm associated with crashes. This is how they decide how roads should be done. Well, I'm going to be leaving you with this, and I'll be sending you these as well. If you need any help, please feel free to give me a call. Have a great week.